So welcome to the Academic-Practitioner Colloquium, jointly hosted by SIAC and the Center for International Law at NUS. For those who are here at Maxwell Chambers, thank you for joining us in person for this event. We also welcome those who are joining us virtually from Singapore and around the world. My name is Emlyn, SIAC's Business Development Manager Legal, and I am pleased to be your MC today. So now we will have the opening address. I'm pleased to invite Mr. Toby Lendo, QC, Vice President of the SIAC Court of Arbitration and Barrister and Arbitrator at Duxton Hill Chambers, Singapore Group Practice. We will also have Dr. Nilufer Oral, Director for the Center for International Law at NUS, joining us online for the welcome address. So, Mr. Lendo and Dr. Oral, please.
A very warm welcome to everybody, both present physically and virtually. This is a very special event, not just because of the subject matter that we are going to address, but also because it is the first partially in-person event that SIAC has run for a long time. And for some of us, it is one of the first events addressing an audience with shoes and socks on. I'm just going to give some words of introduction in order to set the scene for the format of the event, which is a little different to other events. The genesis of the Academic-Practitioner Colloquium came from an idea actually in London some years ago, that in the world of the practice of law, and in particular international law, and even more specifically investor-state law, there are parallel universes that exist but don't always interact properly. That is the universe of academics researching and working on concepts and pushing boundaries and testing ideas, and then the world of practitioners who are out there fighting cases. And the idea was that there would be mutual benefit to bridge the gap between those parallel universes that often don't have actually that much contact. So a series of colloquia were set up in London where we managed to persuade brave academics who were willing to descend from the heights of academe in order to address a bunch of grubby lawyers, and also practitioners who were willing to display how narrow their grasp of law is and their inability to conceptualize. So there was scope for public humiliation on both sides, and it was extremely successful. The idea has come to Singapore, and it's now been going for a number of years here. The concept is the same, which is to bring together current work and sometimes pending work on the academic side and have the academic concepts tested with the help of well-known and respected practitioners. The important point, and especially for SIAC as well as Singapore, I think, is this is an attempt really to raise the bar. So it's not to go through the normal conference structure, which invariably involves too many speakers with too little time, giving superficial platitudes over complex topics. This is a deep dive into some real substantive issues, and it's supposed to be challenging and supposed to be substantive. It remains a work in progress, so all I'll say in closing is that we all very much welcome views afterwards on how the process can be further refined and further shaped in order to get the maximum benefit for all constituents along the way. And that's all I'll say, and wish you all a very good colloquium. Thank you very much.
Yes, greetings to all. It was my intention actually to be with all of you in person, but I will be instead contributing to this hybrid experiment so that we have an in-person welcome and a hybrid welcome. Well, it is really for me, on behalf of the Center for International Law and as director, I'm really very honored to welcome you to this cooperation between the Singapore International Arbitration Center and the Center for International Law, NUS, in organizing this Academic-Practitioner Colloquium. And I thank Toby very much for his very informative explanation of the genesis of this colloquium. We are very honored to be co-hosting this event with the prestigious Singapore International Arbitration Center, and I extend my thanks to the CEO, Ms. Gloria Lim. And may I say, I see that we have an impressive number of signups and participants, which really shows the need for and the demand for such colloquia. In fact, many are participating by Zoom and virtually. So this is a sign that we're not zoomed out entirely. Importantly, as reflected in the title and also the explanation from Toby, this colloquium brings together academics and practitioners, each with extensive experience in their own areas and knowledge. And it's important to be able to share this knowledge and different views. These types of colloquia also advance the mission of the CIL, and as well as which includes actually combining practice and theoretical approaches. I'm going to be short, but I just want to say we have a stellar group of panelists. So I also thank each and every one of them, including the moderators. And I also thank all who have contributed to the organization of this hybrid event from both CIAC and CIL. And I wish you all a most fruitful session. Thank you.
I'd like to now invite Prof. Kalamita and Dr. Giannakopoulos to deliver their presentation. Their presentation is titled Investor-State Dispute Settlement and ASEAN, Do Multilateral Solutions Address Regional Needs?
Very much. Toby, thank you. Nilofer, it's a pleasure to be here today at this latest iteration of the SIAC-CIL Academic-Practitioner Colloquium. I think it was actually almost 5 years ago that we started organizing these colloquia here in Singapore, and it's been more than 2 years since we've actually been able to have one in person. So it's a great pleasure to be able to be here today in a room with real people, but at the same time, it's also wonderful that we've been able to have so many online participants as well. Today, Dr. Harry Giannakopoulos, my colleague at the Center for International Law, and I, we will be talking a bit about some of the ideas contained in our forthcoming book, ASEAN and the Reform of Investor-State Dispute Settlement, Global Challenges and Regional Solutions. It will be published by Edward Elgar later this year. Our presentation will proceed in 5 parts. I'll start off by talking about some of the drivers of ISDS reform, and then looking at the ISDS reform process in UNCITRAL. Then Harry will pick up talking about ISDS reform from an ASEAN perspective and assessing the multilateral institutional reform, such as multilateral investment court, which are being discussed in UNCITRAL from an ASEAN perspective. Then I'll pick up and finish up with some thoughts about reform options that might be considered in addition to those currently being discussed. So let's start with the drivers of ISDS reform. Many of you will know this, but just by way of general background, for the past 20 years, we've seen rising numbers of claims being brought under investment treaties, such that we now know of at least 1,100 such treaty claims. These are claims brought in ad hoc arbitration. They're brought at the instance of the investor, and they can be for substantial sums of money. Claims of more than $1 billion are no longer uncommon, and indeed awards of more than $1 billion are no longer uncommon either. They are also expensive for states to defend. On average, it's estimated that the state will incur approximately $5 million in legal fees in order to defend itself in an investor-state claim. Moreover, the recovery of costs is unpredictable. Just because the state is successful in defending itself against the claim does not ensure that it will receive an award for costs at the end of the day. Rules on costs leave a lot of discretion to arbitral tribunals, and the track record of states in recovering their costs has been mixed. Finally, investor-state arbitration is a lengthy process. On average, it takes approximately 4 years for an award at the first instance, and an additional year in the event that post-award remedies are sought. This is time, of course, that government officials are spending working on litigation and defending the state rather than working on the day-to-day business of government. So it's against this background and with this experience that a number of concerns have been raised by states. And we group them under 4 general headings. The first is with respect to the outcome of decisions. And here states have expressed concern with respect to the consistency of decisions. So for example, the way in which similar or the same treaty language is interpreted and applied from case to case. Similar concerns have been raised with respect to coherence, which is to say how decisions relate to one another and whether they form a coherent body of interpretation and jurisprudence. Predictability has also been a concern, but states having concern about the unpredictable character of the way in which arbitral tribunals may interpret treaties and the way in which they may apply them. And finally, there's a generalized concern about the correctness of arbitral awards. This is, after all, ad hoc arbitration for which there is no appellate remedy, and states have been concerned about the quality of arbitral decision-making and indeed simply whether arbitral tribunals have got it right on the facts of the law. Second heading of concern, the arbitrators themselves. One of the key concerns that states have expressed is concern with respect to the qualifications of arbitrators. There are no mandatory or generally effective rules with respect to the qualifications of arbitrators, and the party appointment system has also led states to have concern. That party appointment system feeds into the next area of concern, which is namely questions about the independence and impartiality of arbitrators. First, there's the concern that within a party appointment system, one sees repeat appointments, particularly with law firms engaging in serial appointment of the same arbitrator in numerous case after numerous case, as well as the concern for the practice of double hatting. Double hatting being a practice whereby an individual may serve as an arbitrator in one case, counsel in another, perhaps even as an expert in a third, leading to questions as to whether or not those varying roles might affect the approach that they take, for example, in arbitral decision-making. Lastly, another concern under the heading of arbitrators is with respect to diversity and representativeness. And here we can have a look at some data, looking just, for example, at the prevalence of arbitrators from Asia in ICSID cases. And as you'll see, ASEAN nationals make up nearly 6.5% of the appointments that have taken place in ICSID cases. And indeed, if one expands that out to all of East Asia, China, Japan, Korea, we still find ourselves under 10% in terms of appointments. Now, a third heading is with respect to cost and duration. And here, as I mentioned at the outset, the awards that are rendered in investor-state arbitration can be very large indeed, particularly relative to the size of some of the economies of the states which are defendants in these claims. Similarly, the cost of defending the state in arbitration is expensive, and the recovery of costs is not assured. Another area of concern by states has been third-party funding and the asymmetry of third-party funding and the inequality of arms that it presents. Third-party funders are, of course, interested in funding claimants because of the upside that can inure to them in the event of successful claim, not so much for states, but the only upside is simply that the state wins and doesn't have to pay. Finally, duration, as I mentioned, it's a time-consuming process. From the state's perspective, it is time taken away from doing the business of government. Final heading is with respect to procedural imbalance. This is a more generalized concern that states have expressed to to the upshot being that states have expressed concern that they've lost control over the system. They've lost control over the treaties that they've drafted and the way they're interpreted and applied, and they've lost control over the process by which disputes are resolved under those treaties. So those are the expressed concerns by states, which are acting as drivers for the current discussion of ISDS reform. So to summarize, we can see how characteristics of the existing system have given rise to concerns as we've described. So the ad hoc dispute settlement system in the absence of appeal, leading to concerns about consistency, about correctness, about predictability. The process of party appointments, the double hatting issue, leading to concerns about ethics, qualifications, and representativeness of the arbitral bar, concerns about costs, concerns about third-party funding, and the duration of proceedings, also featuring prominently in the concerns of states. Well, it's against that background, then, that we can talk about ISDS reform as is currently under discussion at UNCITRAL. The task has fallen to UNCITRAL Working Group 3, which has been mandated to work on procedural reform of ISDS. Now, that's an important limitation. Working Group 3 does not have a mandate to address substantive reform. It is not tasked with examining the way in which fair and equitable treatment should be interpreted or expropriation, nor does it have a mandate with respect to jurisdiction when it comes to ISDS. So the working group is not considering the definition of investor, for example, or the definition of investment. The work began in 2017, and it is expected to be completed by 2026, although it is perhaps anyone's guess whether that will actually happen. Perhaps Jin Hang can offer us a view from the state as to that. Since 2021, the working group has increased its efforts, moving from 2 formal sessions per year to 3 formal sessions, and introducing 3 informal intersessional meetings as well. The reforms under discussion in the working group fall along more or less a continuum. On the one hand, there are discussions with respect to non-structural reforms. By this, we mean incremental reforms which are designed to improve the existing system of ad hoc party-appointed arbitration. Moving along that continuum towards the middle, we have proposals for some kinds of structural reform. And here, the principal reform being proposed is an appellate mechanism or an appellate body, which would not replace the existing system of party-appointed ad hoc arbitration, but would sit on top of it, would essentially be a bolt-on aspect. Finally, at the far end of the continuum, there are suggestions for a complete paradigm shift. And this is structural revision of the entire regime of dispute settlement under investment treaties, eliminating ad hoc party-appointed arbitration and replacing it with something far more judicial, a multilateral investment court. As one looks around the room, there are obvious divides among states. There are states which have rejected outright any calls for structural reform, instead focusing on incremental improvements to the existing system of ad hoc arbitration. Here, for example, the United States, with its great wealth of experience defending claims under the North American Free Trade Agreement, has firmly taken the view that no structural reform is necessary. Similarly, Japan, although not having the same experience as the United States, as a matter of principle, has expressed doubt, if not outright rejection, of structural reform. In terms of structural reform, there seem to be 2 principal camps. The first is that of the European Union, which has championed the establishment of a multilateral investment court. And indeed, is the primary engine behind Working Group 3 having taken up the issue in the first place. In the middle, somewhere, China. China not quite expressing support for a multilateral institution or a complete paradigm shift, but expressing the view that an appellate mechanism for use with ad hoc arbitration would bring benefits to the system. So with that, we come to ISDS reform and ASEAN. And Harry, I'll turn things over to you.
Appreciate the position that ASEAN countries have taken in the UNCITRAL discussions. We first need, I think, to take a step back and appreciate the treaty landscape within which ASEAN countries find themselves. The ASEAN investment treaty landscape is rather complex. ASEAN countries have been particularly active in their investment treaty making over time, but the landscape that they have created for themselves is multi-layered and widely variable in its content. And I will spend the next few minutes unpacking those two claims a little bit more. ASEAN's investment treaty making is multi-layered because a complex web of overlapping treaty relationships exists between ASEAN countries. Now, this graph shows new investment treaties signed by ASEAN and the member states over time. And about 80% of these 383 treaties are currently in force. The first level that we need to pay attention to is the intra-ASEAN level, which is the light blue one in the graph, and includes 24 treaties, which is to say ACIA, and 23 bilateral treaties concluded among the various member states. And already here we can see a first type of overlap. An ASEAN investor is covered by ACIA, and may potentially also be covered by a bilateral treaty that its state of nationality has concluded with another ASEAN member state. The second important level is the extra-ASEAN level, the small red column in the graph, and includes investment agreements concluded by ASEAN as a community with its FTA partners. As of now, there are seven such agreements in place, 6 with Australia, New Zealand, China, Hong Kong, Japan, India, and the Republic of Korea. And of course, the 7th is RCEP, which brings together ASEAN and all of its FTA partners, except India and Hong Kong. An important feature of the extra-ASEAN agreement is that they are plurilateral, meaning that ASEAN is not as such a party to these agreements as a separate legal person. That is because the member states themselves, rather than ASEAN, retain full competence with respect to trade and investment matters. Therefore, rather than all ASEAN countries coming in as a single contracting party, they do so as 10 contracting parties instead, which means that every ASEAN country probably separately and individually owes the same obligations to every other ASEAN member state in the same way that it does to the non-ASEAN contracting party. Because of the plurilateral nature of the external agreement, ASEAN countries may be exposed to legal claims that originate from investors whose home state may very well be another ASEAN country, in addition, of course, to the non-ASEAN counterpart. This option, moreover, for ASEAN investors is available to them in addition to the option that they have to seek protection under ACIA, potentially a bilateral treaty among ASEAN member states, which further expands the scope of potential liability for ASEAN states and ultimately further undermines ACIA's primacy as a legal instrument to regulate intra-ASEAN investment protection. Another complicating factor to this picture is that RCEP does not replace, but rather coexists with all the investment agreements that ASEAN has concluded over time. The third level, which adds even further, I would say, complexity, is the level of ASEAN investment, of the level of the individual ASEAN member states, which you can see in the gray color on the graph. Here one finds 350 treaties concluded by individual ASEAN countries with third countries. And to note, 45 of these treaties are concluded with ASEAN FTA partners, most of which are actually in force. Now, in addition to being multi-layered in this way, ASEAN investment treaty making is also widely variable in its content. This means to say that investment treaties with more sophisticated, more modern, and more reform-oriented language and provisions tend to coexist with less sophisticated, less modern, and less reform-oriented ones. And in fact, the latter outweigh the former. Looking again at the graph, we see that the bulk of the treaties were concluded in the 1990s and to a slightly lesser extent the 2000s. which is consistent with the international trend, shows a similar progression of concluded agreements over time. Investment treaties concluded in the 1990s and early 2000s are known as first-generation treaties. Their overall characteristics are emphasis on investment protection with fewer explicit safeguards for states, and generally wide and unrestricted access of investors to ISDS. In short, there are multiple overlapping treaty relationships among ASEAN countries, as well as between individual ASEAN countries. So investors may therefore be in a position to treaty shop and pick and choose among all the duplicative treaties the one that appears the more favorable to them. So what is then the position taken by ASEAN countries in the UNCITRAL debate? A first observation to make is that there exists no ASEAN position as such. Several ASEAN states participate in the process, yet they do so by expressing their own views and not those of ASEAN as an organization or a community. To the extent that there is an internal coordination of views prior to the meetings, this is not projected during the meetings themselves. Now, this is not to say that we cannot see common threads emerging in the positions that are expressed. Key concerns that have been raised by ASEAN countries include the high costs of proceedings, the general absence of dispute prevention mechanisms in the existing system, and an underrepresentation of the region in the nationality of the arbitrators that are most often chosen, which Jensen already noted earlier, and which is also linked to what is perceived to be a general unfamiliarity of arbitrators with the needs of developing economies. Some ASEAN countries have even gone a step further and have pushed for an expansion of the working group's purely procedural mandate. This is the case for Thailand, for example, and Indonesia, who have cautioned the working group that procedural reform alone is not sufficient. There is thus here an additional, perhaps implied concern about coherence and correctness in judicial interpretations. For example, Thailand has expressed favor for the development of model clauses for substantive investment protection to be included in any final output negotiated by the working group. Therefore, overall, one might say that ASEAN's countries' concerns with investment arbitration are not so much about the legitimacy of ad hoc arbitration as such, but with what seems to be an unsustainable system in terms of the volume of cases that it brings and the resources that it requires to mount an adequate defense. And also with an overall sense that there is lost control over the dispute settlement process as a whole. It is likely this, to our mind, that explains the overall cautious approach one sees of ASEAN countries with respect to structural multilateral reform. Member states have made constructive interventions on the development of reform solutions across the structural and non-structural spectrum, but without committing to either side, at least not yet. And this is also where we see some divergences in the views expressed. For example, Thailand is the most vocal in its skepticism of an investment court, and to some extent also an appellate mechanism. More neutral and open-minded, towards a court at least, we think is Singapore. Although it is important to note that open-mindedness and neutrality so far have not translated to outright support either. The remaining ASEAN countries have generally been cautious to not express a clear position yet. They seem open to discussing the possibility of a court and a standing appellate mechanism. However, our overall sense would probably be one of likely reservation towards the prospect of at least an investment court. Now, is a cautious approach justified? Based on the current stage of the discussions that UNCITRAL described earlier by Jensen, the answer is probably yes. To be sure, institutional design in a permanent instrument can address some of the concerns that ASEAN countries have expressed. For example, a court can include processes on dispute prevention and mediation, or it can put in place strict time limits for every stage in the process. Yet important concerns that ASEAN countries have may remain unaddressed. And I have three sort of broad concerns here to mention. One such concern is coherence and correctness in judicial interpretations. The critical feature from ASEAN's point of view here, recall, is the large number and variable content of investment treaties concluded by ASEAN and by the member states. One could perhaps foresee minimal coherence if a court or an appellate mechanism adopt a treaty-by-treaty approach to their interpretation of those treaties. To be fair, it doesn't seem very likely. What may seem more likely is that we see high levels of coherence, but through a process of what we call forced homogenization, of carefully bargained for treaties. Because after all, homogenization is what would probably be expected of a permanent court or a standing appellate mechanism. However, homogenizing treaties in this manner may not necessarily lead to quote-unquote correct interpretation. A second kind of concern that would remain unaddressed would be representation and unfamiliarity with the needs of developing economies. Discussions in the working group on the exact number of adjudicators and the modalities of their appointment in a permanent structure are still at a preliminary stage. The model under discussion at the moment seems to be about a fixed bench, which means that selective representation will probably be the rule. And in that scenario, it is unlikely that ASEAN countries will see greater levels of geographical representation than they see in the current system. Lastly, a third kind of concern has to do with costs. Again, remuneration arrangements for adjudicators can be devised so as to make permanent structures more cost-efficient during disputes. But there are still relatively low levels of investment litigation brought against ASEAN countries or brought by ASEAN investors against third states. For context, there have been only about 40 investment cases to date brought under treaties concluded by ASEAN or by an ASEAN member state, although there has been a steady filing of cases every year in the last decade. It is, however, an open question whether those kinds of numbers justify joining a multilateral court or an appellate mechanism, and assuming the prevailing overhead costs it takes to maintain them. Therefore, joining in multilateral solution, as this is currently being considered and discussed in UNCITRAL, is, we think, not an obvious choice for ASEAN countries. And on that note, I would hand it back to Janssen to explore prospects for developing regional solutions.
Thank you, Harry. Well, given our concerns that multilateral reforms being considered in UNCITRAL might not address the priorities expressed by ASEAN member states, we think there's a need to reconsider the reform agenda and reform solutions through an ASEAN-focused lens. And in doing that, we suggest a range of ideas, some of which are admittedly blue sky in nature, but which we think are worthy of serious consideration, nevertheless, given the unique opportunity presented to ASEAN by this reform debate. To that end, I want to address three regionally focused options for consideration. The first, an ASEAN investment tribunal. The second, some particular RCEP-specific opportunities. And thirdly, the possibility of ASEAN-focused solutions within the context of a multilateral institution, such as the MIC being considered by UNCITRAL. Now, when we talk about an ASEAN investment tribunal, what we have in mind is a dispute settlement mechanism with broader or narrower jurisdiction to hear claims brought under ASEAN's investment treaties. So in its narrowest conception, one can imagine an ASEAN tribunal as having jurisdiction to hear claims under the ACIA and the bilateral investment treaties entered into between the member states, the so-called intra-ASEAN option on the screen. Now, the comparative advantages of this intra-ASEAN option would be the increased degree of coherence and predictability brought about by having specialist adjudicators interpret and apply ASEAN's treaties. And moreover, an ASEAN-only tribunal would by its nature result in a bench or in a roster of adjudicators who are representative of the region and familiar with ASEAN and its legal traditions. Now, more broadly, one can conceive of other permutations of an ASEAN investment tribunal, which would involve ASEAN's FTA partners, at least those with which ASEAN has agreed to ISDS. One permutation such a tribunal could cover are these agreements, plus possibly a future RCEP. While another permutation could actually involve not only the ASEAN plurilateral agreements with its FTA partners, but also the ASEAN member states' individual bilateral agreements with those FTA partners as well. Now, Given the overlapping and multi-layered way in which ASEAN treaty making has taken place, as Harry laid out, with investors potentially being protected by 2 or more treaties, this latter option would at least have the benefit of bringing all of the member states' treaties with the FTA partners under one regime. And as with an ASEAN, intra-ASEAN investment tribunal, this approach would potentially allow for considerable comparative advantages to a multilateral institution. Finally, in thinking about an ASEAN investment tribunal, it's important to note that we've put that phrase in inverted commas. And that's to emphasize the flexibility available to structure dispute settlement in a way which addresses member states' concerns. So while an ASEAN investment tribunal could entail the wholesale replacement of investor-state arbitration as we know it, removal of party-appointed arbitrators, it need not necessarily do so. An investment tribunal might entail simply retaining the party-appointed system of ad hoc arbitration, but adopting a standing appellate mechanism, or replacing pure party appointments with rosters of potential arbitrators, or any number of varieties in between. Now, building off of these ideas for an ASEAN investment tribunal, it's worth giving some special consideration to RCEP. As Harry mentioned, RCEP includes an investment chapter, but does not yet include an agreement on ISDS. In principle, given its scope, RCEP presents a unique opportunity for member states to capitalize on the comparative advantages of regionalism. The unique opportunity presented by RCEP is that the members and their partners have the benefit of writing on a blank slate, at least as far as RCEP is concerned, developing investor-state dispute settlement solutions with the kind of flexibility that I've just described. And at the same time, RCEP, in principle, offers an opportunity for ASEAN and its member states to clean up the chaos of their investment treaty relations by harmonizing both substantive and procedural rules. Now, of course, those of you who are familiar with RCEP as it currently stands will know that at the moment RCEP does not do this. Rather, as Harry has noted, RCEP leaves in place all of the existing investment treaty relationships under both the ASEAN investment treaties with the external partners, as well as the bilateral investment treaty relations between the individual member states and those external partners as well. At least with respect to the pursuit of coherence, predictability, consistency, therefore, replacement of duplicative treaties remains a central priority for any reform effort that ASEAN considers. The practical challenges to these ideas for an ASEAN-focused and designed system of investor-state dispute settlement are considerable. We don't underplay that. At the same time, given the flexibility that ASEAN member states would have in designing an ASEAN-focused system, they need not be insurmountable. In particular, we'd note again that RCEP presents a unique opportunity for ISDS reform in ASEAN, which is likely not to be available again for some time once the dispute settlement chapter under RCEP has been finalized. Now, lastly, we think it's important as well to consider how ASEAN concerns might be accommodated within a multilateral institution, such as is now being discussed in UNCITRAL. Because even if ASEAN member states can't move forward with ASEAN-focused and designed reform solutions, then the concerns which they've expressed nevertheless remain and need to be addressed as best as possible. So focusing again on the concerns raised regarding coherence, consistency, correctness, as well as concerns with respect to representativeness and diversity of adjudicators, we suggest a number of ways in which these concerns might be addressed. To this end, we suggest the possibility, consideration of specialized tribute chambers within a multilateral investment court, which might be fashioned to address either particular treaties, such as large regional arrangements like RCEP or CPTPP, or that might address the treaties of particular states' parties, such as ASEAN member states or ASEAN and its FTA partners, for example. Now, that said, in considering this approach, it bears noting again, as Harry mentioned earlier, that although discussions in the working group on the exact number of adjudicators and the method of their appointment are still at a preliminary stage, the option being discussed at the moment is focused on the establishment of a fixed bench. As a result, unless there can be some flexibility in this respect, such as the establishment of separate benches based on retainer arrangements with the use of closed rosters, it may be difficult for these principal ASEAN concerns to be addressed. Nevertheless, these are real concerns for ASEAN states, and this is a unique opportunity for those states to adopt meaningful reform to address those concerns. That concludes our presentation. Thank you.
Thank you, Prof. Kalamita and Dr. Giannakopoulos. We will now have the 55-minute panel discussion on the presentation. The moderator is Ms. Koh Sui-Yen, SC, partner at Wong Partnership LLP. We have a mix of online and in-person panelists. They are Mr. Rodman R. Bundy, Senior Partner at Squire Patton Boggs, Singapore; Dr. Johan Cox, Head of International Arbitration at Shoesmiths, who is joining us online; Mr. Ong Chin Heng, Senior State Counsel, International Affairs at the Attorney General's Chambers, Singapore; and Dr. Vincent Joelle Prout, Associate Professor at the Faculty of Law, NUS, who is joining us online.
Thank you very much for that introduction. Good day, everybody. I'm delighted to be here in person, to see so many of you in a three-dimensional instead of a virtual format. I also welcome my virtual friends who are dialing in. I'm very fortunate to be able to moderate this discussion because it allowed me to have a sneak peek of this fascinating book, which is extremely thought-provoking. It took me many hours and I brought it to bed with me. My official role is to moderate this discussion. That I will certainly do. But what I also intend to do is to spark a debate and hopefully ignite some flames amongst the speakers and try to get them to disagree instead of agree with each other. So if I can just start off by calling on Johan, who's dialing in from London. What you bring is the London and EU perspective. And I just wanted to understand from you, how do you think it is different from an ASEAN member state perspective? How do you think, from an ASEAN member state perspective, the manner in which they approach and their experience in investment treaty making and ISDS would affect how they engage in this global debate about ISDS reform? What are your thoughts on this?
Hello, everybody. Very nice to join you. This, just to be clear, this isn't the presentation. This is just a question, yes?
Yes, it is.
Yes,
And then
yes, indeed. So yeah, I think that there are differences between all the countries in terms of, as Janssen has said, the structural and the degree to which countries, regions and blocs would like structural and non-structural reform of the system. We see in the EU, it's certainly a push for structural reform, and this is different to ASEAN. We're going to expand on this in the panel discussion, I'm sure. So I won't say too much, but there are stark differences between the positions being taken in the global debate.
That's great. Chin Heng, I think you bring with you a very interesting perspective, because we speak about how the idea of this discussion is to bring and to hear from the academics and to hear from the practitioners. And you come with this government perspective, being a leading member of the delegate at the UNCITRAL Working Group. So how do you see ASEAN experience affects its role in ISDS reform on a global stage. How is it different from how EU has approached ISDS reform in this working group discussions?
Thank you very much, Sui. And where would you like me to begin? I could speak for 2 hours on this if you want, but maybe let me first start off by thanking SIAC and CIL for organizing this event. And I heard earlier on with great interest that this is actually the first post-pandemic in-person event. So I feel extremely privileged to be here, looking at everyone in 3 dimensions, as Suyen mentioned. But on top of that, also interacting with some 200, 300 other participants on a 2-dimensional basis, no doubt. But I think in terms of numbers, we have this additional reach, and I'm really very grateful for that. And I wanted to also at least start by thanking Janssen and Harry for an excellently put together book. I won't say that I brought the book to me to bed every night, unlike Suyen, but I did spend several hours looking through it, and this is where I must respectfully beg to differ from Toby, who had earlier characterized this apparent divide or a disjunct between academics on the one hand and practitioners on the other, because I actually thought that the views and the insights that they brought to the table through the book were absolutely spot on, and I did not get the sense that there was this ivory-towered sense about the observations or recommendations that they were making. So I want to start with that as the backdrop. Now, turning to Suyen's challenge as to the difference, I suppose, that you see manifesting itself in ISDS reform discussions, such as those happening at Working Group 3 of UNCITRAL, I would say that first and foremost, it is true to a large extent that, very much unlike the EU, ASEAN does not have that same kind of a unified or common voice. I would put this down to a few reasons or a few observations, which I stress I have to make in my personal capacity, because I obviously cannot purport to speak for any of the ASEAN member states, including my own. But from sitting in the room, I can understand and I can see that the EU, first and foremost because of its structural differences from ASEAN, is in a position, and in fact has to take a much more coherent and harmonized and homogenized position in these discussions. Not least because the EU is not ASEAN, and ASEAN is not EU. We do not have the same level of integration. We do not have the same level of shared, I suppose, experience or lived experience or shared perspectives as the EU. And so, to that extent, I would suggest that it is inherently more challenging for a relatively looser grouping of countries like ASEAN to express anything close to a coordinated position. And in that regard, I think Janssen made the observation during his presentation that it might have been Harry who said that they did not discern that ASEAN member states in these discussions seek to coordinate or have a common position, and I suppose that is true. I would like to also point out that the disparity of experiences amongst the different ASEAN states would be a prime, a main reason for that. Amongst the 40 odd ISDS cases that have involved ASEAN states, you will find that there are some ASEAN states that have faced more ISDS claims as respondents. Some have yet to face any ISDS claims as respondents. On the flip side, we find that there may be investors from certain ASEAN member states that have utilized ISDS or
the BITs or FTAs, as well as the ISDS procedures, somewhat more frequently than the investors of other ASEAN states. And so in that sense, the experiences of the different ASEAN countries is different. And I would see that explains to a large extent the disparity in the ASEAN position. I could go on for a lot longer, but I think I should not belabor this point. Thank you very much.
Thanks, Chin Heng. Joanne, I then thought that it would be nice to hear from you, because hearing from Chin Heng about how ASEAN is structurally different from EU, how ASEAN has sort of disparity amongst the ASEAN member states as to their different levels of involvement in ISDS disputes and the various challenges that they face. Do you think that a complete structural overhaul or a more targeted, incremental, non-structural reform would be more suitable in an ASEAN context?
I would have thought that the latter, a more targeted, incremental, non-structural reform, may be appropriate, certainly as a starting point, because as Chin has emphasized, that there are big differences between the EU in terms of their levels of integration and different experiences to ASEAN. So if you just look at the EU, it's an integrated model politically, economically. It has its own parliament, its own legislation, its own court system. It's a very advanced model of integration, and it certainly has been pushing an agenda for reform on a structural level. And I think Chin made very, very valuable points that there are differences between not just states, but blocs. And so I'm sure all the rest of the panelists will have views on this, being in Asia, but I would have thought a step-by-step, non-structural, more targeted discussion certainly would be beneficial, and then move forward from there. In terms of a structural overhaul of a system, I think there are big questions. What is the driver of that agenda? Is it political? Is it needed? What's wrong with the current system? Can that be fixed? As Janssen pointed out, there are criticisms of the current system, but there would be criticisms of any new system. Would a court, a multilateral court, be considered part of an establishment, in the sense that it's already there's criticism that there's too few of too often the same arbitrators are appointed in ICSID cases. So you can just look ahead and see, well, look, if there's a multilateral court or more structural changes, and there's a fixed tribunal, a fixed court, there would be similar criticisms of that. So I think these are really big questions, and I know that they're being debated at UNCITRAL, and that's very important. So I think we need to just step back and think that that's a very, very important question. Should it be structural, or should it be a more targeted incremental change? There's many tools to states' arsenals at the moment. They negotiate treaties. They can include in their treaties carve-outs, exceptions, explanations. So already there is arsenal in the state's possession to be used. So yes, I would say a step-by-step incremental approach would be welcome, but I'm sure the other panelists will have their views too.
And that's when I turn to Chin Heng. Do you agree with what Joanne just said, that a step-by-step incremental approach is the way to go for ASEAN member states? Or do you think that more sort of decisive steps should be taken, for instance, to negotiate a further treaty, which is something that's mentioned in the chapter?
Okay, so if I can if I can circle back to, I think Johan's observation, I must say that I agree with with what Johan has described as a matter of reality. Coming from what I said earlier about how the ASEAN states have had differing experiences, I can understand why this is likely to end up being the track that ASEAN takes generally on ISDS reform. I would recall that earlier I talked about how ASEAN and the EU are different structurally and in terms of the level of integration. I also mentioned how the experiences of the 10 ASEAN member states are quite vastly different in the ISDS space, both from a respondent state perspective as well as claimant investor perspective. But a third angle that I didn't mention earlier, but I think I should probably mention now, is the fact that the ASEAN member states have also had different experiences and their treaty negotiations. And in this regard, I think it's quite well known that at least amongst the 10 ASEAN states, there are 2 ASEAN states that have entered into investment treaties recently with the European Union, namely Singapore and Vietnam. And in these 2 treaties, the EU-Singapore IPA and the EU-Vietnam IPA, you see manifested for the first time, right? The creation of an investment court along the lines that has been described in the book, but in a bilateral format rather than in a regional or a multilateral format, which is the kind of format that Working Group 3 is now talking about. So even where investment treaty making experience is concerned, there is that diversity of experiences, and I think it would not be a surprise to observe that because at least Singapore and Vietnam have gone in that direction, these 2 countries are more familiar with the idea and the concept of establishing a court as opposed to, carrying on the ad hoc arbitration model of ISDS. I would also like to recall that I think there are at least a couple of other ASEAN states that are in the process of negotiating similar treaties with the EU. I think Indonesia might be one of them. And these countries that are also undertaking their own investment treaty negotiation journeys with the EU as a partner are also obviously having to deal with and address and examine the features, the advantages and potential disadvantages of the reform model that the EU advocates in its treaty making. Given this additional data point or this difference, I would foresee that the road ahead to a harmonization of an ASEAN position will be relatively long, but that journey might very well be shortened by multilateral developments or multilateral, how would you say, successes, right? That might emanate from Working Group 3 in the coming years, which, amongst other things, might create at least an appellate mechanism, if not a full court with 2 layers, a first instance layer as well as an appellate layer. If some of these products actually emanate at the multilateral level and start to gain a relative level of familiarity or comfort amongst the international community, I can see that from there might actually be some movement on the ASEAN front for similar, I won't say homogenization, but similar dovetailing of their interest level in having such reforms in a regional setting. So I think I'll leave it there. Thank you very much.
Thanks, Chin Heng. I think what you've just stated does bring up many question marks. It starts first with EU, who's always been a very strong advocate of a multilateral investment court. And that is a very structural approach to ISDS reform. And through the investment treaties that they have entered into with Vietnam and Singapore, they have managed to, in a sense, as part of the treaty negotiations, reach a state where the ASEAN states, both Vietnam and Singapore, are comfortable with a bilateral investment court system, and the treaty has been signed. So I then want to turn to this deeper question, which is we've heard from the presenters that there are concerns, and the whole movement towards ISDS reform really comes from concerns as to the consistency, coherence, predictability, and correctness of the decisions by tribunals. So would a standing appellate mechanism, which you talk about, a multilateral investment court, be able to effectively or efficiently address these ISDS concerns? And maybe I would turn to the gentleman from Montreal. I think that's where you are, Vinjo. And hear from you on that.
Hi, nice to see everyone. I'm actually in Vancouver, Canada. Greetings, everyone. The short answer would be no, not in the ASEAN context, I think, in terms of the multilateral investment court. My sophisticated legal analysis is as follows. It's complicated. As the authors show, I think in the book, which by the way is fantastic, I really enjoyed it, ASEAN economic agreements are increasingly reform-minded of the structural non-incremental type, with the exception of that we've just discussed with Singapore and Vietnam signing up with the EU model, for far more far-reaching structural sort of reform. So in some ways, I think the stage is partially set in ASEAN. I wonder if the political will is there as a full bloc. Obviously, a standing appellate mechanism would almost exclusively be geared towards tackling concerns relating to consistency, as you said, coherence, predictability, correctness of arbitral awards, and so on. For one thing, I think that the fact that it would rely on a roster of permanent adjudicators might arguably result in greater cohesiveness and consistency in decision-making and so on, when you compare that to the current fragmented ad hoc sort of model. In theory, I would say that a standing appellate mechanism or the appellate tribunal of the MIC should address concerns of correctness because of one key underlying objective, which is we can correct errors of law, right? But we can't lose fact of the pesky little reality that Japan has raised in the working group number 3, that appellate adjudicators themselves can get it wrong on the law, right? So hopefully that will be a pervasive trend going forward, but something to consider. So the good news is both options provide considerable leeway, I think, and flexibility to parties in terms of institutional design and so on. I think particularly important for ASEAN and beyond would be to define the grounds of appeal, standard of appellate review, the remand powers of an appellate mechanism, and so on. So that's the sort of pro view, but I'm still a bit skeptical. So I think there's some important limitations which are brought up in the book. Producing consistent decisions within these frameworks will largely hinge, I think, on similar content across the IIAs, the agreements that are falling under the mechanism's jurisdiction, right? So let's not forget, potentially we have a pretty considerable amount of agreements that could fall under that umbrella. So that's something to consider, and that will affect coherence and consistency maybe. So that's why I think that the presenter's argument in the book that is more fleshed out about forced homogenization is persuasive to my mind, meaning that this kind of new structure might lead arbitrators in this system to force consistent interpretations on seemingly different IIAs, even though they might be actually different in actuality. And those differences might have been the product of the long and arduous negotiating history, which this new structure might now jeopardize. So obviously, the idea is the more similar the substantive content and the wording of these treaties or these covered agreements is, the easier it is to envisage a more organic push towards consistency and coherence. But by the same token, the more states buy into this type of structure, i.e. a multilateral model, the more I think it shrinks geographical representation of ASEAN and its legal traditions and the understanding of the realities facing the global south, which has been a concern expressed by some delegations. And this is true also in the MIAC context. So I think the MIAC, to sort of heed these concerns, would have to be carefully designed to accommodate ASEAN specific realities and address broader concerns over ISDS. Things that are canvassed in the book like streamlining preconditions to arbitration, clarifying the MIAC's subject matter jurisdiction, like we see in Article 25 of the ICSID Convention, to exclude certain types of disputes, prohibiting the exercise of diplomatic protection when you have for a national investor that has a pending case before the MIAC, like we see in Article 26 of the ICSID Convention, clarifying the relationship between the MIAC and other available dispute settlement options with a view to providing exclusivity to the MIAC over these other avenues. So these are all things to consider, I think, going forward. Should ASEAN member states sign on to an MIAC or the standing appellate mechanism structure, it will be straightforward to incorporate that structure into future IIAs. But a bit more challenging to do so with existing older generation agreements. So as the authors, I think, rightly point out, a treaty amendment is a legally effective, but diplomatically onerous and time-consuming sort of exercise, which ASEAN member states might not be inclined to pursue across the board. So I agree, I think, with the authors that the best way forward under this option is to conceive of MIAC's constitutive instrument as an opt-in convention to keep existing IIAs in place, but to subsume them under the mechanism's jurisdictional umbrella. And that would have the effect of multilateralizing key provisions in those instruments. Another point I want to raise, if I can sort of abuse the privilege of having the floor, in the MIAC context, challenges related to consistency, coherence, and predictability might arise if only a certain amount of ASEAN member states join, which is likely, or at least will join in a staggered fashion, if at all. So in that scenario, an investor from a home state that is not party to the MIAC could accept a unilateral offer to arbitrate from a host state that is a party to the MIAC, or decline it, right? In which case it would allow that investor to pursue other ISDS avenues enshrined in the covered agreements. So this situation obviously might not only lead to undesirable multiplication of procedural rules and potential arbitral forums with respect to the same host state for that investment, but to the same sort of potential issues related to incoherence and inconsistency we're discussing. So as the authors point out, I think in the book very helpfully, there's ways to safeguard against that in the MIAC, right? By providing, for instance, for reservations, declarations, to ensure reciprocal access to the MIAC, a little bit like we see in some optional clause declarations under the ICJ statute. Another sort of safeguard the authors, I think, cleverly put forward is what they call MFN bars, right, in the book, which would be aimed to prevent the claimant investor from using the MFN clause in a relevant IAA to take advantage of more favorable non-MIC ISDS provisions, whether they're reformed or not, contained in another IIA between the host state and the third state, right? So that's basically the key points I wanted to bring about. By way of conclusion, I would just say, in the abstract, the idea of an MIAC is attractive because it holds the promise of an institutional framework through which control can be asserted on how cases are handled at first instance and on appeal, providing a bench of permanent arbitrators that will be working very hard towards consistent development of the law. But that would-be consistency that we're striving for under the IMAC, that coherence, that predictability, that correctness could really only be pursued on a treaty by treaty basis. There may be no surefire way of harmonizing or coordinating treaty interpretations, I think, across all covered agreements, short of engaging in a forced homogenization, as the authors put it, and homogenization of hard fought for agreements, as they suggest. So the takeaway is, despite all these reform initiatives, I think the field will remain fragmented to some extent. So I think I'll stop here for now.
Thanks so much for that, Vinjo. So I guess from your perspective, the answer is it addresses some of those concerns, but will not fully eradicate all the ISDS concerns, even with a standing appellate mechanism or multilateral investment court. I then want to turn to Rod, so that he can come from a practitioner's point of view, having had the experience of appearing before many investment tribunals, before the International Court of Justice, before the Iran-US Tribunal. And I wanted to get his sense on what do you think about the establishment of a regional investment tribunal for ASEAN? Do you think that is going to be the solution?
In the long run, perhaps, but not in the short term. Before I get into some practical issues I want to raise, I do want to congratulate the authors of the book. It contains a great deal of very useful information, thought-provoking ideas, and obviously a lot of research went into it. So well done. What I'd like to do in the few minutes allotted to me is to focus on some really nuts and bolts practical issues that I think arise that have not been addressed yet, either in the manuscript or they've been touched on a bit by Jin Heng, but let me develop them a little further. Now, we've heard that the authors focus on 4 interrelated issues that states, apparently even ASEAN states, consider a source of concern: the consistency of decisions, coherence, predictability, and correctness. And they're all legitimate concerns, but my question is, how likely or feasible is it, or even necessary under the present circumstances, that the establishment of an ASEAN regional tribunal will be able to satisfactorily address those 4 concerns? Now, in my opinion, an investment tribunal or even an appellate investment court is only as good as the judges or arbitrators who sit on those bodies, and perhaps to a lesser but still important extent, the registry or secretariat that administers the proceedings. Now that raises the question, which I'll put in purposely stark and perhaps provocative terms: where will the individuals who sit on or act as the secretariat for an ASEAN investment tribunal or appellate court be drawn from? Will they be up to the task? Can they guarantee the consistency, coherence, the predictability, and correctness of decisions that's sought? Now, aside from the obviously complex political and legal implications that establishment of such a tribunal will have on existing ASEAN BITs or multilateral trade agreements, which the authors have addressed in their study, is ASEAN really ready for such a development? Now, in this connection, I was struck by some of the statistics set out in the treatise, and they were put up on one of the slides earlier. ASEAN nationals have apparently participated in what I would call a judicial role in 56 ICSID proceedings. I'm not sure about UNCITRAL or other proceedings, but these were ICSID proceedings. But 33 of those 56 concerned matters involving appointments as members of an annulment committee made by the institution, not by the parties to the annulment proceedings, and not as arbitrators on the merits of the case. ASEAN nationals have only been appointed as arbitrators on the merits of cases in 23 instances. But if we go back to the overall number of 56 appointments, 34, as we saw, were from Singapore, 12 from Malaysia, 9 from the Philippines, and 1 from Thailand. I'm not sure what the breakdown would be if you only consider the 23 cases that involved arbitrators sitting on the merits, not on annulment committees. Now, either way, according to the study, 6 of the 10 ASEAN member states have never had one of their nationals sit as either an arbitrator or a member of an annulment committee in an ICSID investor state case, and a 7th, Thailand, has had just 1. Now, I'd respectfully suggest that it's not enough for members of an ASEAN regional tribunal to be familiar with developing country needs. That was flashed on the screen earlier. I take it as a given, or at least I consider that it should be a given, that individuals who are charged with deciding investor-state disputes within the framework of an ASEAN investment tribunal or appellate court should have a solid knowledge of the law in the field, including relevant aspects of public international law and certain principles that have contributed to what is often called a jurisprudence constante. Professor Calamita suggested that states are concerned that about the qualifications of arbitrators, independence, impartiality, diversity, and representativeness. Yes, fine. But how are investors and states alike to be confident of the consistency, coherence, predictability, or correctness of their decisions unless the decision makers are knowledgeable and respected in the field of ISDS? Where will these individuals come from? Just Singapore? Maybe Malaysia or the Philippines? How will the other ASEAN states react to that? What will the qualifications be for individuals to sit on an ASEAN investment tribunal? And if one concern is to avoid double hatting, in other words, individuals sitting as arbitrators in some investor-state case and acting as counsel in others, are those individuals from ASEAN countries who might have the requisite legal formation and experience to sit on a regional and investment tribunal ready to forego the possibility of acting as counsel in investor-state disputes, including as counsel or even sitting as arbitrators in non-ASEAN or non-ASEAN regional tribunal institutions? Anybody want to raise their hand? I don't know. And that's not to mention the need to have a strong secretariat or registry familiar with how investor-state disputes are handled. And then there's the question of language, which is critical since a number of ASEAN states may be hampered by a lack of experienced jurists with a genuine fluency in, let's say, English, French, or Spanish, which are the 3 official languages of ICSID. I'm not saying they'll be the 3 official languages of an ASEAN tribunal, but what language is going to be used? That's the next question. In short, while I think the notion of an ASEAN investment tribunal is undoubtedly worthy of consideration, I think that there's still a good deal of capacity building that needs to be undertaken before the idea can become a reality. I commend CIL and I commend SIAC because they've had considerable engagements in building regional capacity in the fields of international arbitration and public international law, but I think more needs to be done, particularly amongst ASEAN member states who may not have as much experience either in conducting investor-state arbitrations or certainly as acting as decision makers in such cases. And then one last matter that isn't addressed in the study. What about the views of investors regarding the establishment of an ASEAN investment tribunal? It takes 2 to tango, after all. Will investors regard an institution that comprises decision makers nominated by the member states as likely to be sympathetic to their position and claims, given that the ASEAN member states are invariably respondents in investment arbitrations? Or do the views of investors simply not matter? They just take what they can, whatever's given to them. And again, I found the statistics that the study marshaled quite revealing. They show, and I think Jin Heng touched on this, that there have only been 12 cases where the claimants to an investment arbitration are from an ASEAN member state, and of those 12, only 3 involve claimants in intra-ASEAN proceedings. In other words, in proceedings where the investor was from the ASEAN member state and the respondent was an ASEAN member state. That suggests, as far as I can tell, at least as things presently stand, there may not be much of a market for an ASEAN Regional Investment Tribunal, at least now. And even if the jurisdiction of an ASEAN Regional Investment Tribunal is expanded to include non-ASEAN claimants, sophisticated investors, often advised by law firms familiar with international dispute settlement resolution, increasingly structure their investments so as to be able to take, obviously, advantage of investment treaties or multilateral agreements that provide them with recourse against the state where the investment's made, preferably with neutral party-appointed arbitrators. And as long as other forums or forums are available, other options of forums, thus this tribunal wipes out all the other possibilities and all the BITs and free trade agreements, there is a strong possibility that investors will choose one of those other options where they can at least appoint their own party-appointed arbitrator, unless and until an ASEAN Regional Tribunal establishes a track record that is balanced in its approach to investors and states alike, or is the sole jurisdiction available. Now, I don't want to, I'm being provocative on purpose. I recognize one has to start somewhere, and again, I congratulate the authors for a job well done. While the days of an ASEAN Regional Investment Tribunal may lie in the future, and it may be a better chance to have some sort of appellate mechanism first, circumstances obviously may change. And so then once again, I think this was a valuable contribution to this whole concept. Thank you.
Rod, thanks so much for that. I thought that the Secretariat could be filled by Center for International Law, so we don't have to worry on that front.
Well, you better ask the rest of us then.
Wait, not SIAC?
No. Actually, I wanted to call on Joanne to see whether she had any thoughts on what Rod just mentioned. Because one of the questions that's always been raised in these debates is always, how do we choose? How do we get the good quality roster of arbitrators? You get the same question faced even when you have an appellate mechanism. Who is going to be the parties that constitute this the appellate body? So, any thoughts on that, Joanne?
I would agree with Rod's points. I thought they were all very, very well put. We can't lose sight of the investor in all of this. So yes, in the discussion of whether there should be regional or multilateral investment courts and who should comprise the tribunal, this is going to be, what say will the investors have? You know, it's all very well for the states to make appointments, but who will those appointments be? Will they be retired judges? Will they be competent? Will they have expertise specifically in investment treaty arbitration? Will there be political appointments? How will we safeguard against all this? We already see criticism in the existing system in the existing appointments made in investment treaty disputes. The same arbitrators are appointed time and time again. Janssen was very, very right in what he said. Law firms look to see track records of arbitrators. Where did they come down on substantive issues? So how can, if there is going to be a list of arbitrators or a roster of arbitrators or tribunal members or court members, whatever you will call them, we must safeguard to make sure that the voices of the investors are heard, as well as the states, to make sure that it's not seen as an establishment, to keep it very open, to ensure diversity. We have many different regions, not just Europe, not just Asia, we have Africa, we have the Americas. So to make sure it's truly representative. And then also, if we do have a court system, we haven't touched upon here, and it's very relevant, the system of binding precedent. So whereby, yes, the discussion is procedural at the moment, but it touches on substance in this respect. International law does develop, maybe just slightly in certain areas, but if we do have appeals, what will be the limits of those appeals? And will it choke the development of international law in any way? So we just need to safeguard, we need to very much safeguard in terms of tribunal appointments, in terms of investor expectations as well as states, keep the system open, question the fundamentals. Is it necessary? Go back to basics. Rod touched on this point, and I think it was very well made. What's wrong with the system now? Does it need reform, and in what way? So there's a momentum now for reform. We have the UNCITRAL working group, but if you look at ICSID, they've just reformed their rules. They're voting on it, the member states this month. The changes will come into place in July if they're approved, but that's an incremental change. That's working within the system. They consulted the public, they consulted states, they made changes to their rules. So I think that we just need to step back in this whole debate and just ask the very basic questions too. What's wrong with the system at the moment? Is change necessary? And if change is made, how can we safeguard to protect everybody and to address all the concerns on the table? Some spoken, some not spoken. So that's what I would say. Don't know what the other panel members have their thoughts on this too, I'm sure.
Thank you so much for that. I should let the audience know if any of you have any questions, please put your hands up and we will take them. Vinjo, do you think that the views of investors are not taken into account, or in a sense being disregarded, when the states start entering into all these treaty arrangements where they decide to be the parties that nominate who they want to be on this regional ASEAN Investment Tribunal, or who they want to be on this appellate body? Does this then go back to the old days? It's like we've gone back to square one.
Yeah, all very good points. I agree with a lot of the points that were made by our two colleagues who spoke previously. Certainly, I think that the views of investors are important. Are they taken into account in practice? I can't really speak to that. But what may happen is that investors might lose their appetite for this kind of new structure if there's systemic issues with it. So one example, moving away from the regional ASEAN court option back to the MIC, if maybe this could happen in the ASEAN context, but let's go to the MIC. If the nomination process is highly politicized or politicized at all, and is not done in a sort of ideologically balanced way, that might put off certain investors from using this mechanism because, let's say, they perceive a pro-state bias on the MIC or things of that nature. So those investors might be compelled to prefer alternate avenues to protect their investments. For instance, through investment contracts that contain more traditional, if you want, ISDS clauses with a reference to or possibility to go to more traditional international arbitration. So that's, I think, an important thing to remember. The more sort of, I think, fundamental question that this raises is that this EU-led model towards this multilateral investment court really does away with party appointed arbitrators, right? It's party appointed arbitrators no more, if we had to do a tagline for a movie. And basically, obviously, I think some claims about the concerns over ISDS have been exaggerated, especially in academia. But that recent move away from party appointed arbitrators led by the EU and towards, I would argue, state control over the appointment of ISDS adjudicators through this multilateral investment option that the EU is spearheading, suggests, yeah, there might be some deeper truths to some of these concerns and so on. It's telling that Vietnam, Mexico, Singapore have signed on to these types of structures. But basically what the Europeans are doing is taking the prevalent historical model, which won by default. Each party gets to appoint an arbitrator. You get two, one on each side, and then the third presiding arbitrator, sometimes to split the difference and so on. You still have 1, 2, 3 arbitrators deciding the cases. But like claimant investors, states like to choose their own arbitrators to decide the specific cases they're in. And they've remained partially sort of faithful to this tradition, but they retain the control over appointments of whatever the roster or the adjudicators will be, while investors are completely dispossessed of this pretty fundamental right. So I think that's a fairly problematic thing, aspect of the reform, and whether their views are taken into account or not, I think this would be a game changer for many investors.
Thank you so much for that. Ching Heng, what about you from the government perspective? And I do know you're speaking in your personal capacity, not representing any ASEAN member state.
Right. Thank you very much, Suyan, for putting me in the spot. Seeing as such that I'm the only government lawyer amongst a group of practitioners and academics on this panel, I suppose it is incumbent upon me to respond to that. But what you might find to the extent that you might have been trying to broker some sort of an outright dispute on this panel, I have to disappoint you, because far from taking umbrage at that at the suggestion that the appointment mechanism is going to be in any institutional setup is going to be deeply stacked against the investment community, I would like to kind of like set the record straight that at least where Singapore is concerned, since we are notoriously pragmatic and almost annoyingly realist in the positions that we express and the kinds of suggestions and proposals that we may make in an international forum such as this. This is something that actually resonates not just with me personally, but I think it's something that colleagues and I have had the chance to actually think through and think deeply. The kinds of sentiments that Rod expressed, and I think which were echoed also to a certain extent by Vincent, Joelle, and Johan. You'd be surprised to find that when we speak at the working group, that's literally 2 weeks ago, because the rubber is now hitting the road, and working group 3 is in fact now talking, looking at the devil in the details and discussing specific provisions that have been drafted by the Secretariat as to the manner of appointment of adjudicators, the methodology of selection, etc. And to an issue like this, we have quite clearly said that all stakeholders should be considered, and the investing community is a large stakeholder. Hell, it's actually half of the equation if you think about it, right? And so when it comes to things like the selection of nominees, there are certain options on the table, such as every contracting state of this institution gets to nominate its own national, or a nominee of its own nationality. We have actually spoken up to suggest that actually the nomination methodology should be a lot more inclusive, a lot more diverse, a lot more in keeping with maintaining equitable geographical diversity, as well as gender balance, as well as balancing the interests of different stakeholders. And I think we would be very much more in favor of nomination method that allows for self-nominations, or nominations by the investing community, whatever that may be. And of course, we have to define these kinds of things following maybe an open call. So I don't think that it's necessarily the case that member states, because it's a member state-led initiative at Forum Led Working Group 3, that it's not necessarily the case that it's going to be so deeply stacked, because I think there are delegations, apart from Singapore, but the US, etc., that also have a healthy understanding of the bigger picture at hand. And so I think I would be a little bit less skeptical about it, whilst acknowledging that the devil is very much still in the details. They are still being worked out. This is a long negotiation ahead, but it's not as if these views are not being even recognized. So I'll leave it at that.
Now, please.
Even if states were to nominate tribunal members on any type of multilateral investment court or an ASEAN regional tribunal, is that really so shocking? I mean, on a domestic level, parties have to bring claims against government entities before courts with judges nominated at some level by branches of government with the same paymaster. Is it really so shocking? Again, being slightly controversial here.
Yes, it's open to all the speakers who are sitting here in person as well. Yes, opportunity to advocate the points in your paper.
I think that point is very well taken. Of course, there's nothing unusual about private parties appearing before judges that have been appointed by states. We expect this in domestic legal orders. We respect this in other regional courts. So I'd like to push back a little bit on some of the skepticism, if not to say pessimism, about the multilateral project more generally, and at least the potential viability of a institution, whether it be an ASEAN institution or a multilateral institution. There are problems with the existing system. This is why states are seeking to reform. They're not seeking to reform because they're beholden to NGOs, but because the experience that they have undergone over the past 20 years has led to concerns about the way this system is functioning. So with respect to whether or not adjudicators from developing states, from ASEAN, or frankly Africa, or other parts of the developing world are ready to do it, well, the fact of the matter is that the experts that we have in place have actually given rise to the concerns that have led us to this point of inflection. And of course, we would have to have judges or adjudicators who are qualified, in addition to being representative. That goes without saying, I think. But again, who's to say that this isn't possible? Yes, there are some bad examples out there, the Iran-US Claims Tribunal being one of them, but there's also the WTO appellate body, there's the European Court of Justice. There are risks, of course, but there are also possibilities. There are not many cases, and there wouldn't be many cases, it seems, certainly involving ASEAN at the present time. One wonders if an agreement with the size and scope of RCEP might actually change that. And of course, investment treaty planning is possible. This is always possible, and unless and until we have a multilateral treaty on the substance and a multilateral treaty on the dispute settlement process, this is going to remain a fact of life for states. So I don't think there's any way around that if one is looking to reform in a structural way. And lastly, investor concerns are absolutely important. And to my mind, investors really are not sufficiently heard in Working Group 3. And frankly, nor is the arbitral bar, which has experience with these kinds of cases that can be used to inform some of the solutions. But I think, to agree with JiaBin Huang, even if there are those concerns, even if you factor in the need need to bring investors on side so that they have confidence, they see the legitimacy of the reforms. That doesn't mean that the reforms can't or shouldn't go forward. Thank you.
No.
I kind of just downloaded.
No, Jensen, I thought that was a very strong push for the position that you have put forward in your chapter, where you do discuss and explore the possibility of having an ASEAN investment tribunal. And what I wanted to do, because we are out of time, is actually to take a vote now on this last, and having given you the advantage of the last word. Do you, in the audience and on the panel, now stand convinced by Jensen that what Jensen is saying is that this is possible and this is the way forward? Structural reform and the possibility of an ASEAN investment tribunal. Put your hands up if you say yes. You do have some votes, Jensen. I do think your book will be purchased. With that, I do bring an end to this session because we are over time, and I thank you so much for the presenters, for that fascinating book, and for my speakers, both here as well as virtually. Thank you very much.
We have come to the end of the SIAC-CIL Academic-Practitioner Colloquium. Thank you to all our speakers as well as our participants. Thank you, and we hope to see you again soon. Have a great evening, everyone.